Hi everyone, welcome back to Law with Dunk the Law Guy, and we're on day 10 of the Case a Day series where, at least from Monday to Friday, I will go over legal cases relevant to criminal law, tort law, contract law and the English legal system. For day 10, I'd like to introduce the rules of causation and how these form part of the actus reus of many criminal offences. I'll then link this to the first test used for causation and how it links to a case called R v Pagett, 1983. First of all, there are conduct crimes, and for these types of crime there is no result and so no consequences needed to be proven. Hence, therefore, the rules of causation aren't needed at all. With a conduct crime, the defendant's action is the crime, such as speeding or committing theft, so there is no injury or death. This also includes the criminal offences of assault, which is an act that causes the victim to apprehend immediate and lawful violence, and battery, the unlawful application of force. You can see that with both an assault and a battery, there is no injury. However, unlike conduct crimes with consequence or result crimes, these crimes require the actus reus to cause an outcome or consequence or result, and therefore the rules of causation are needed for these types of crime. The rules of causation are required to connect the defendant's actus reus to the victim's injury or death, i.e. consequence, and this is why the rules of causation are needed for criminal offences, such as the non-fatal offences against the person, where injuries varying from actual bodily harm to grievous bodily harm or wounding have been caused. Clearly, the rules of causation would be needed for murder and different types of manslaughter, as death has been caused, but not for an attempted offence such as attempted murder, as the full offence, i.e. murder, has not been fully committed. Where the rules of causation are needed for a criminal offence, the prosecution must prove that the defendant's conduct was the factual cause of the victim's injury or death, that the defendant's conduct was the legal cause of the victim's injury or death, and that there were no breaks in the chain of causation via any intervening acts. For factual causation, we use the but-for test. Here, the defendant can only be guilty of a severe crime that requires the rules of causation if the victim's death or injury wouldn't have happened but for the defendant's act or omission. So we ask the question, but for the defendant's conduct, i.e. act or omission, would the victim have suffered death or injury? Dependent upon the crime, of course. Let's apply this test to R v Pagett, 1983. In this case, the defendant took his girlfriend, Gail, who was pregnant, hostage and went on to use her as a human shield whilst firing at police officers. The police fired back, killing his girlfriend. Pagett was convicted of Gail's manslaughter, as but for Pagett using his girlfriend as a human shield and firing at police officers, the police wouldn't have fired back, killing her. Therefore, Pagett was held to be the factual cause of his girlfriend's death. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you tomorrow.